All rise. The Court of Appeals Division 1 is now in session.
Good morning. You may be seated. So we are here in our case number 1CACV170156, DIAZTECA Company versus Palenque Foods International, LLC. Counsel, as you know, both sides are allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of it for yourself. The clock on the podium will reflect the total amount you have remaining, including what you might have decided to reserve. We record these proceedings, so we'd be grateful to you if when you approach the podium you would recite your name and the name of your client for the recording. We have read the briefs and studied the record. We've also discussed the case in our conference this morning. So with that, you may proceed.
Good morning. My name is Jennifer Maldonado with the firm of Burris & McComber, and I'm here to represent Palenque. May it please the court, counsel? We're here, I should start out by saying I'd like to reserve 3 minutes for rebuttal. Thank you. We're here today because the trial court abused its discretion in granting the preliminary injunction that DIAZTECA requested. In abusing that discretion, it can be done in a couple of different ways, as you know, applying the incorrect law or standard to the issues, or basing that decision on a clearly erroneous finding of fact. In this case, we actually have both. Preliminary injunction, as you know, is an extraordinary remedy. It really may only be awarded when there's been a clear showing that the plaintiff is entitled to such relief. And in order to establish that they're entitled to that relief, the plaintiff needs to establish 4 equitable criteria. In this case, the plaintiff, DIAZTECA, could not even get past criteria number 1, which is a strong likelihood of success at trial on the merits. And
Counsel, I'm particularly interested in the restrictions on the ability of the defendants to accept business that just comes in the door from existing clients of DIAZTECA or prospective clients on the one hand, and then also the restrictions on the defendant's ability to elicit that business from existing clients and prospective clients. So I'm not sure I understand what the injunction as modified does with respect to those 2 categories.
Your Honor, first, you're absolutely right that it's interesting that the court tried to restrict the new company, Palenque, from being able to do business with people that it may or may not have done business previously with DIAZTECA. There are a lot of sort of preliminary steps that the court should have made findings on to even get to that point that it didn't and could not have based on the evidence. For example, that those employees who were then with Palenque had never even been with DIAZTECA.
Well, what do you understand the injunction to do in those 2 categories?
What we understand the injunction to do is to not allow Palenque to have any kind of an employment agreement, a sales agreement, any kind of attempt at a sales agreement with any customers that used to be involved with DIAZTECA, or that at any point were formerly involved with DIAZTECA.
So may not accept business from a client that is or has been a client of DIAZTECA?
That's our understanding,
May
yes.
not accept business.
And may not solicit.
And may not solicit from any company that is or has been a client of DIAZTECA.
That's our understanding, yes.
Well,
which is overly broad.
But didn't the court modify that to talk about existing clients for which the individual defendants had developed a business plan?
Yes, and as we pointed out in our brief, Your Honor, that makes it extremely difficult for Palenque if we were to assume that the court was correct that these former employees of DIAZTECA, which actually were former employees of a Mexican company not related to DIAZTECA, but that being the case, if they did have information about who had previously been involved with DIAZTECA, DIAZTECA wanted them to keep that secret. They didn't want that. They're claiming that was confidential. So how are we supposed to then turn around and tell Palenque you can't have...
To get back to the beginning, though.
Yes.
You first say that the injunction barred the defendants from accepting any business from any DIAZTECA client. But that's not true, is it? Because you've just, I think, agreed with me that the court modified the injunction to bar defendants from accepting business from a DIAZTECA client only if the defendants developed a business plan for that client.
Yes, I apologize.
Okay.
You're right.
Sorry, and weren't you wasn't your client okay with the as modified order? Was there a different objection after the modification?
That's a good question, Your Honor, and I apologize that I wasn't the attorney at the initial hearing, so I don't have personal knowledge of that. My understanding is that the appeal is of the modification as well, due to a variety of factors, including the fact that
But if you ask for a modification and the court goes with what's requested and seems to have addressed it, it seems like a difficult argument to make on appeal that was an abuse of discretion. If the parties understood that, and it does look like there's a focus on clients who were developed while working for DIAZTECA, that seems to be a limitation. But again, I guess I'm a little bit troubled by there's a request for a modification and the modification is granted and no further discussion of that. No, that doesn't work.
You're right. It may seem a little inconsistent on its face. My understanding of it is almost sort of like a lesser of two evils sort of thing. The first injunction was significantly overbroad and was not borne out by the facts presented by the plaintiff at the evidentiary hearing. The modification was better, but still is able to be appealed based on the legal standards. With regard to back to the plaintiff's burden at the initial hearing, as I indicated, there was no clear showing that this plaintiff was even a proper employer of any of these former employees who went on to allegedly work for Palenque. The plaintiff is the one who brought this hearing, who had all of the ability to prepare for it. They did not bring anybody to testify or any evidence to support that these former employees were actually former employees of DIAZTECA, other than this Mr. Diaz who testified, who clearly explained to the court that the Diaz family apparently owns a lot of different businesses. And when he said that they were employees, he meant they were employees of a Diaz family business.
What about the employment agreement that was offered into evidence?
That was interesting as well, Your Honor, because although it did say that it was a DIAZTECA document, it wasn't signed by any DIAZTECA employees. The only signatures on those documents were the former employees themselves, which in the hearing, Mr. Diaz said that he didn't see any of them sign. He wasn't there for any of them to sign it. He said that he did recognize one of the employees' signatures, not the other two. We don't know when those were signed or under what circumstances or where, or whether perhaps the Diaz family used those DIAZTECA forms in some of their other businesses without changing the business name. We don't know what happened because the plaintiff didn't tell us. It was their burden. So the evidence was very unclear as to whether they were even employees of DIAZTECA. In fact, he admitted that they were employees of this Mexican company called Agricola Santa Virginia, and that company paid them. In these employment contracts, there has to be some sort of a consideration. And I use the word employee contracts kind of broadly here. It's not a contract for employment. It's a contract that's sort of ancillary to employment that goes to confidentiality and competition and things like that. But it doesn't say we're going to employ you. It just says you're an at-will employee, and while you're here, you have to do these things.
Does that matter if the signer of the contract, and we'll assume it was signed for purposes of this injunction, agreed to certain restrictions? Does it matter whether the context was as an employee or as something else?
It does matter, Your Honor, because if it was a true contract for employment with DIAZTECA, then there would be a much stronger argument on the plaintiff's side that they were employees of DIAZTECA, and DIAZTECA is therefore the proper plaintiff here. However, if this is simply a confidentiality agreement that is ancillary to employment with a Mexican company that is not DIAZTECA, then DIAZTECA has nothing to do with them. They don't pay them. They don't employ them.
It seems implicit, though, in signing an agreement that lists DIAZTECA. Why isn't there an implicit employment agreement with, why sign something with DIAZTECA as an employer if you're not viewing that as an employment relationship, regardless of who pays the check? It seems like there's an employment relationship with DIAZTECA, and you agree to a confidentiality agreement as part of that relationship. It just seems implicit in agreeing to this confidentiality agreement that you have some sort of employment relationship with DIAZTECA.
It seems that's what the plaintiffs were hoping would be the analysis by the court, and it apparently was. We don't believe that's accurate, simply because, Your Honor, in the case law that goes through these sorts of restrictive covenants with relation to employment, there does need to be some sort of consideration. If the employee is agreeing to not compete or to not give up information that they learned through the course of their employment to use it in the future to compete in the marketplace with the skills that they've learned, they need to receive something for that. Normally in the case law, that's looked at as either payment because they're currently employed by that company, or continued employment because they're not going to be fired.
Does it matter if the check is cut from a parent corporation or some other corporation? If DIAZTECA just has an agreement with, complete unrelated, the checks are cut from just some company that has a different name, why does that suggest that there's not an employment relationship? When the document says it is a confidentiality agreement in connection with, I mean, it just seems implicit that there's an employment relationship with DIAZTECA.
I understand your position. I respectfully disagree. If I sign an employment agreement with the courts saying that I'm not going to give anything confidential that happened in court, but the court's not paying me to do anything, and I'm not working for the court, I work for Burris & McComber, why do I owe the courts anything? What are the courts giving me in response? Just a silly analogy, but
wouldn't there have to be, it seems like there's at least the threshold with this agreement. I'm going to assume unless somebody comes in and says, no, I've never worked for this company, and there certainly isn't anything like that, but if on its face this seems to show that there is an employment relationship. And if you want to come in at trial and say, no, I absolutely didn't work for this company, I mean, that's one thing, but nobody came in here and challenged that.
Right. And our response to that, Your Honor, would be that it's not our burden. It's a preliminary injunction, which is a very preliminary stage of the proceeding. It was not a trial. It was their burden to prove that they were the plaintiff, that they had this relationship with the employees, that they had a legitimate enforceable contract, and these kinds of contracts aren't even always enforceable by the courts anyway.
As modified, as the injunction was modified, does it make any difference? Because the injunctions, I mean, it seems to me the injunction only bars the defendants from approaching or accepting clients with whom they engaged on behalf of DIAZTECA. And so if they were engaging on behalf of DIAZTECA, whether they were employed by DIAZTECA or not, the injunction comes into play. But if they didn't engage with these customers or would-be customers on behalf of DIAZTECA, employed or not, it doesn't make it, then they're free to do what they want. So does the actual employment make any difference?
Let me see if I'm understanding your question right. So if our position is that they were not employed by DIAZTECA, they were employed by a Mexican company. So if they had approached, let's say, Costco as an employee of the Mexican company,
on
not
behalf
DIAZTECA,
on behalf of someone else.
But they didn't.
Why are they barred? If the language in the injunction just says anyone that you approached or developed business, presumably for DIAZTECA, that I don't know how else you can read the injunction as modified. So that again kind of assumes an employment relationship, and if it's not there, then they didn't do it, then they're not barred from doing it.
Right, and we addressed that a bit in our pleading as well. That it's almost like a concept of no harm, no foul. If you weren't doing it on behalf of DIAZTECA, you're not barred from doing it now on behalf of PALENQUE. But that's not the standard that the trial court should have been using when it issued this preliminary injunction. They had to prove that our employees were doing something on behalf of DIAZTECA for them to even get,
Well, and they
3 or 4
offered some
steps.
evidence. I mean,
Some evidence.
I wanted to ask, actually, what's the status of the litigation now? Has there a trial been set?
No, everything is on hold, as I understand it, pending the outcome of this appeal.
Okay.
So let's see. Getting back to wrong plaintiff, DIAZTECA was not their employee. There was also no employment, as I indicated. Just like the cases that we cited in Miller with the H&R Block case, when Ms. Miller was no longer working for H&R Block, her H&R Block employment policies were no longer enforceable against her staff. The same sort of situation should apply here. They were not employees of DIAZTECA. They were employees of this other Mexican company that was not a parent company, as Your Honor used that phrase. It was just another company owned by the same family, apparently. But that doesn't mean that one company's employment agreements should be enforceable against all of the rest. DIAZTECA could have done a lot of different things to prove that they were actually the correct party. They could have brought in different witnesses. They could have brought in people who were in HR or who hired or who supervised these particular employees while they were allegedly at DIAZTECA. They could have brought in timesheets, W-2s.
To rebut what little evidence was offered.
That's
Nothing.
correct. And again, it wasn't our burden to do so. It was their burden to prove it by clear evidence that they could.
Evidence at this stage? I'm not sure the plaintiff needs to prove very much.
Why isn't it clear evidence if someone just says these people worked for DIAZTECA? Isn't that clear evidence? Someone says these were employees of DIAZTECA.
Had he said that unequivocally, perhaps. He said they were employees of Agricola Santa Virginia in Mexico. They lived in Mexico. They worked in Mexico. When asked on redirect, well, isn't it true that they were DIAZTECA? Then he was like, well, yeah, it's all owned by the Diaz family. But it was very, very clear, and that's his family. That was Mr. Diaz, the vice president.
But if you take the redirect, why isn't that enough absent something that rebuts that? If he says, albeit on redirect, yeah, they are working for DIAZTECA.
He also said they weren't paid by DIAZTECA. They were paid through the Mexican company. The totality of the circumstances, Your Honor, was not sufficient for the trial court to find there was a clear
showing.
showing.
The payment part of it, there's just no evidence on payment. If you just have somebody that says they work for DIAZTECA, and we don't go into who's paying, why isn't that enough, absent somebody coming back and saying, no, I didn't work for them? If someone just says these people work for DIAZTECA and nobody shows up to say anything to the contrary, why would you necessarily need to develop more evidence on that issue?
As I said, had that been all he said, perhaps that would have been reasonable, but that wasn't all he said. He said they work for the Mexican company, which is not DIAZTECA. Their own witness said that. I think that's significant. The credibility of the witness was significantly lacking, and I know that that's something that is normally left to the trial court to figure out because they were the ones that were there and could hear the inflection and see the witness and all of those things. However, on all of these different issues that he was not clear on, that he equivocated on, and that there just simply wasn't very much evidence on, they didn't meet their showing. And thank you for the reminder. I have about 2 minutes left, and I'll reserve the rest of the time for rebuttal.
Thanks. Roy.
Good morning, Your Honors. My name is Mark Lambers, and I represent DIAZTECA. And this basically is a case where where Palenque is complaining of a failed litigation strategy and wants this court to bail it out. And I'll explain why later. What the court has to determine is whether the trial court abused its discretion when it granted the injunction and denied the motion for new trial. And the burden is also on Palenque to show that the factual findings were clearly erroneous. They cannot just demonstrate that the court abused its discretion in entering the injunction or denying the motion for new trial, or that the factual findings were clearly erroneous. There are sufficient facts in the evidence that supports this injunction and supports her findings of fact. DIAZTECA is a family-owned business. It imports produce and other food products into this country. They had 3 employees. One was a sales manager on Menta. They worked for a period of time. They all signed the sales agreement. It came out through testimony that Mr. Diaz may not have witnessed the signatures himself, but as a company policy and course of business, he was able to demonstrate that those documents were in fact signed by these employees and were company records and kept in the course of company business.
Did he say, as counsel says, that they were employees of the Mexican company, not of the Arizona company?
Frankly, his testimony is choppy, and it's choppy for 2 reasons, and I was there. One is there were lots of objections made by Palenque's counsel, which kind of stopped the flow, and the court had to jump in many, many times to try to clarify thought. And the other reason, it's not in the record, but he's primarily Spanish speaker, so he had some difficulty with English. And
what's his clearest statement that these are employees, that these were employees of DIAZTECA?
In his redirect. It was clear in his redirect that these were employees of...
And do you have that handy, just what it was that he said? If you don't, that's fine.
I don't have it. But it was clear in redirect that they were employees of DIAZTECA. In fact, he testified that while they were in the United States, he, in fact, at times traveled with them to buyers as DIAZTECA employees, made sales pitches to buyers as DIAZTECA employees, and in fact, in the agreement itself says that they are DIAZTECA employees. All of that is sufficient under the facts that's before the trial court, not the facts that they try to get in later, but the facts that were in front of the trial court for her to make the decision that she did. And it's sufficient on its face. The facts support that they were employees. One of them started a business while he was still working at DIAZTECA. 6 months later, he leaves DIAZTECA. The other 2 employees leaves. These are non-solicitation agreements. They're not non-competes where they can't compete in a different business once they leave. They can, and we limited the agreement in that way. We didn't want to prevent them from working. But the restriction, as Judge Johnson zeroed in on, is not that they couldn't accept business from other buyers from DIAZTECA. They can accept business from buyers from DIAZTECA. They just can't accept business, or they can't solicit business from buyers who they had a relationship with by developing a business plan.
How about accepting business? What are the restrictions under the injunction from the defendants accepting business?
I think the restriction is that
Solicited, yeah. It's not clear to me what the court meant when it modified that. C.
I think that the modification means that they cannot direct, solicit, accept business. It says, but it was modified later.
They're pursuing business?
Pursuing business. That's the key.
So that's different than accepting. If someone just makes, if a customer calls, they would not be precluded from saying, okay, yeah, sure, we've got stuff we'd like to sell you.
Correct.
That's not pursuing?
That's correct. That's not pursuing.
So is it your understanding then that C in the original injunction, accepting any business or account transfers from any DIAZTECA client or prospective client, that's out?
I believe the accepting was out. It was just only, they were only directed at not soliciting business from customers which they had some type of relationship with, and it was based on some business or marketing plan that they developed while at DIAZTECA. That's my understanding of the modification, which was agreed upon.
And just out of curiosity, is this the type of industry where customers come to the business? Or is this something that only business is only developed by someone calling? Or does it happen both ways?
It happens both ways, but the primary way is the business, DIAZTECA goes out and solicits business and develops relationships with customers, knows the buyer. For example, Walmart. A normal produce importer or seller couldn't just call up Walmart and say, give me Bill, I want to sell some mangoes. You need to have that relationship. You need to know who the buyer of mangoes is at Walmart and develop
Why isn't
that.
there just one phone call to Walmart and say who's responsible for buying mangoes?
Because that won't get you to Bill. You have to have that direct contact because they
wouldn't tell you who's in charge of their produce department if you called?
They probably would, but I suspect Bill wouldn't take the call. That's why the relationship and the business cards and what they stole was so important, because this is like most businesses in sales, it's based on relationships. You build a relationship with an individual. You know this person, Bill, buys mangoes. You know Sally buys pineapples. You have their emails. You have their cell phones. You can call them in a moment's notice. So that is information that's not public. It's confidential, and it was confidential, and it was kept confidentially by DIAZTECA, and that's what they took. And that's the advantage a company has in this business, is having these relationships and having someone at their access, either by phone, email, cell phone, immediately to say, hey, I got these mangoes ready to go. You want them? What's your price? So I think.
And this is a 3-year restriction. After 3 years, they're free to do whatever they want. Is that the?
That's correct. It's limited in scope. I think it's pass muster on any temporal restrictions. And again, I go back to, we didn't restrict them from competing in the business. We're just restricting them from soliciting customers that they developed while they worked for us under an employment agreement where they themselves acknowledged they were employees, and when they went out to make sales, they represented themselves to be employees, and that is in the record.
Did the defendants return the business cards?
No.
And there's no stay of the injunction issued, right?
No.
Has there been litigation on that, on the failure to return the business cards?
There has not. The difficulty is my understanding that I've been told that PALENQUE doesn't have them, that it's maybe the employees, they're in Mexico, there's issues about exercising jurisdiction over them. We did get jurisdiction over them under the lawsuit. They were in the U.S. at a trade show in Florida, and we were able to get them served. But we haven't litigated that issue with respect to business cards. Unless there are any other questions, I have no other comments other than, again, to remind the court, the standard is abuse of discretion. They haven't shown that it's been abused, and they clearly haven't shown that the factual findings by the trial court were clearly erroneous under the evidence that was presented at the hearing, not the evidence they try to get in later. Thank you.
Very briefly, Your Honor, in rebuttal, Your Honors, I have a copy of the transcript from the preliminary injunction hearing, and on the second page of the cross-examination, he was asked a question by Mr. Carl Macomber for our firm. Isn't it true that all of the employees that are named as defendants in this case were employed by Agricola Santa Virginia? Answer, yes. And on the page before that, in the very beginning of the cross-examination, Mr. Diaz himself had identified that particular company as what he called a sister company with the same owners, and that company is in Mexico, according to his testimony. With regard to the confidential information on the business cards, first, case law that we've cited in our brief is clear that names, phone numbers, emails that can be easily obtained, as the court mentioned in its questioning of the appellee, are not that difficult to obtain, and they're not considered confidential information. The case Mascari that we cited is in the same exact industry, the produce industry. I believe that one was a lettuce case rather than mangoes. But as you indicated, sir, you can just call and say, hey, I've got a great price. I think Bill really wants to talk to me.
Why is it unreasonable in the context of you've agreed not to pursue business from clients that you've developed previously? Why doesn't that just make sense as this is the way we're going to enforce that restriction or that limitation that you've agreed to? So it doesn't do you any good to have those cards if you've agreed not to solicit business on their behalf, and that it just goes to it just seems to be evidence that's pointing in the direction that you are actually soliciting business, pursuing business from someone that you pursued it from while working for DIAZTECA.
My time is out.
Please,
I'm allowed? Thank you.
I've got a question after that, so go ahead.
Our position is that there is no information that has been presented to the court that the business cards were taken by these 3 employees of the Mexican company, or that they had ever been provided to Palenque or were ever used by Palenque.
If we were to conclude that the Superior Court did not abuse its discretion in finding that, at least at this stage, that the individual defendants are bound by the employment contracts, then and did not abuse its discretion in finding that those contracts cover the information on the business cards, are the defendants arguing that the restrictions on accepting or soliciting business are overbroad?
Yes.
How so?
Because the employment agreement was not applicable to Palenque or to those individual former employees.
Okay, but I'm saying forget all that.
Right.
If we
You're saying that it is.
yeah, then as modified, is the injunction overbroad?
I believe it is for the statements that I mentioned earlier, that we would have no way of necessarily knowing without disclosing information without those former employees disclosing information to Palenque about that confidential information. Palenque would not know.
So
It's like a catch-22. They want us to not
so the
disclose
defendants
it,
would
but they
have
want
to,
us to disclose it.
So the individual employees would have to say to Palenque, okay, we worked for these 10 companies.
Yes.
Why is that an unreasonable burden to put on Palenque? If you said you've hired people who signed an employment agreement that said they won't compete, that they won't solicit or pursue business from people they've previously pursued business from. So if you're going to hire them, knowing that they have that agreement, why is that an unreasonable burden to say you've at least got to tell the employees you can't do that, so we need to know who you solicited business from? It doesn't strike me as being unreasonable in that context. But you're just challenging it just on its face. It's overbroad.
Yes.
I mean, you're saying it's a catch-22, and it would be a catch-22 if the employees would have to disclose confidential information. But if all they're asked to disclose is the identity of the company, how is that? Is that a catch-22?
Well, it's difficult to answer because, our position is that all of the information that they're saying that they've presented thus far that was on those business cards is not confidential. Names and phone numbers and email addresses are not. It's not as if you can fit on the back of a small business card a whole lot of information about pricing that was developed or how much they bought when and histories of this, extensive relationship that they had. We're not talking about something that was kept under lock and key.
Why can't you just ask the employees who you did business with when you were at DIAZTECA?
Well, we could, and it's our position that we can contact them as well. So that's where I'm saying that we just disagree.
What? I'm sorry?
You can contact the customers or the employees?
The customers. because it's our position that the initial employment contract is not enforceable because it was the wrong party.
All right, thank you. Thank you
you.
both lawyers for your briefing and your argument. We'll take the matter under advisement and issue a decision in due course. We'll recess for a bit to allow the next case to set up. Thank you.